Couple of things. I would like to acknowledge the support for the gathering and the dinner last night by the National Center for Truth and Reconciliation. They were kind and generous enough to host us, so acknowledge their generous contribution. I would like to also speak to the issue of our three mechanisms and the representatives from MRIP and Vicky and Miriam around a joint statement that could come out of here from the three mechanisms, which would support the International Decade for Indigenous Languages, which would follow the 2019, that the three mechanisms, voices together, heard together, is incredibly important, and we're very fortunate to have all three here today, all three representatives from all three mechanisms. There is a paragraph in paragraph 50 in the Permanent Forum records of 2016 that calls for an international decade. And the idea is for the three mechanisms to have a joint statement on that issue, which would then, the group of friends, we call the group of friends, would be Canada, Ecuador, Bolivia, many different states who are very supportive and advocate on behalf of Indigenous peoples at their missions in New York, at the UN in New York. We'll take that up with a group of friends, and as well, I will take up that joint statement with the Indigenous colleagues who are members of the UNESCO Steering Committee responsible for the International Year, and raise this issue at the UNESCO launch on January 28th in Paris, and one-day high-level UN General Assembly meeting on February 1st in New York. And so that's the idea, is to begin that work. At the end of the year in December, there will be a closing plenary, high-level meeting at the UN, where we hope that we will have by then completed an outcome document following the International Year. And that's kind of the trajectory that we're on. It is, as was said by Willie, a very exciting year, and an important year for us. The very essence of who we are, transmitted from generation to generation, is through our languages and the teachings through our languages. So with that, we do have a very important session this morning, building on the very important session yesterday with all of the tremendous presentations from the speakers. We have a lineup here today from representatives this morning on this third panel. Grand Chief Willie Littlechild, not a stranger to anyone here by any means, highly regarded in this country. He's wearing a beautiful jacket here, and he's been inducted into Canada's Sports Hall of Fame. Imagine. We're very so proud of his achievements in this country, and we always stand him up, and he is a guiding light for all of us. Naiomi Metallics, an assistant professor at the Dalhousie School of Law, University of Dalhousie. She holds a master's degree from Osgoode and is the first Mi'kmaq person to clerk at the Supreme Court of Canada. That's an incredible achievement to be proud of. And Alexey, member of the expert mechanism on the rights of Indigenous peoples from Central and Eastern Europe and the Russian Federation. 2014 to 2016, he served as vice chair and chairperson rapporteur for the expert mechanism. Worked as a translator, journalist, executive director, and as an individual entrepreneur, but a really strong advocate for Indigenous languages as well. So we'll begin with those three, First speaker, Willie Littlechild.
Well, thank you very much, and good morning again to each of you. I thought I would start with the title of this conference. I recall one time I was at the United Nations when the declaration was being worked on. And in the old days, we could speak up to 5 minutes at the UN, because there weren't very many of us, right, in a room. So when we came to the article on languages, I thought, you know what I'm going to do? I'm going to speak for 5 minutes in Cree at the United Nations. And I did. Not one word of English. And I was looking at the interpreters, as you know, they're sitting up there. Boy, they were getting really, really angry with me. You could see them moving around and flipping papers. And then I asked the States, I said, how did you feel? How did you feel when you did not understand what I was saying, when I was speaking in my own language? So can you imagine how my ancestors, our ancestors, felt at treaty time when languages were being used that they didn't understand? So I got a round of applause, and they said, we don't do this at the United Nations either. We don't clap for anybody. But anyway, Kiskinohamatowin, it's a Cree word. And I'm going to throw out 3 other Cree words. Kiskinohamatowin is actually, it means to teach each other or to learn from each other. And that was a good term to use based even on yesterday's experience. I learned so much from the presenters yesterday. But if you listen to my words, oh, by the way, tell another story, because I thought this was important too. Have you ever heard a language die? Every 2 weeks, an indigenous language dies somewhere in the world. And one time at the UN, as the Indigenous Caucus, we were having trouble, we were having difficulty with each other. We were kind of actually angry and arguing amongst ourselves. And one of the delegates said, do you know what? We didn't start our meeting with a prayer this morning. We didn't start with an invocation. Let's ask old man here to see if he will offer thanksgiving for us. So they offered protocol to the old man, and he said, you know, yes, I'm very, very honored to be asked to say a prayer for us, but I want you to listen very carefully to the sound of my voice. Listen to the words I'm going to speak to thank Creator, because I am the last living speaker in my community of our language, he said. So he prayed for us in his language, and about a month later, I got a phone call, and the caller just said, the old man just died. And I said, what old man? Remember the old man that prayed for us at the UN? Well, he died. It was almost like somebody just hit me right in the gut, because I actually did hear an indigenous language die. So it's really important that we celebrate this year. So Kiskinohamatowin it's a Cree word, but so is Opintowin, Sagihtowin, Wichihtowin. Do you notice what the last 5 letters of those words? Sagihtowin, Kiskinohamatowin. It's not Sagihtoluz or Opintoluz or so it can work both ways for us in Cree. So we're blessed to have our language like that. So let me build on what our really illustrious speaker yesterday, Daly, mentioned a couple of things. One of the things she said was to focus on implementation of the UN Declaration at the national level or at the local level. But she also observed that there was a lack of monitoring of these. No one is really monitoring what all is happening in the international arena with respect to Indigenous people. So I hope to show you a couple of ways we've tried to do that through the Truth and Reconciliation Commission calls to action. So when Celeste asked for case studies, I had one I could offer on treaties, but I thought I would offer one on reconciliation, a case study on reconciliation in Canada. So what I'm going to do is show you how we've made an effort through the Truth Commission by making 94 calls to action to Canada after the Indian residential school impact and legacy. What can we do to promote and advance reconciliation? So I've broken it down into 4 areas. What's happening at the federal level, both by Canada and Indigenous peoples. Provincially, what's happening at the provincial and municipal level, and what's happening among ourselves as Indigenous peoples to implement the UN Declaration, and what's happening in private industry, just to give you an example. But yesterday, our elder focused on the 7 sacred teachings when he gave us an opportunity, a blessing yesterday morning. So it was a very important aspect of our work in the Truth Commission to rely on those 7 sacred teachings. Indeed, when the courts ordered us to have national events, we took a sacred teaching as a theme for the national events. So at the close of the commission after 6.5 years, we came down to some conclusions in terms of what areas do we need to work on in Canada to try and repair the harm that was done in Canada. And if you remember the Prime Minister of Canada of the day, when he apologized on behalf of Canada to the residential school survivors and the students, he mentioned that there was a lot of harm done by the residential school policy. So we decided to break the report into thematic areas. And of course, the very first call to action that's really relevant to us here today was that we called on Canada to use the United Nations Declaration on the Rights of Indigenous Peoples as the framework for reconciliation. And indeed, right after the report was done, the Secretary General of the United Nations, Ban Ki-moon, referenced our report and called on the world to use this as a roadmap for reconciliation. So how do we do that in our country? I think that yesterday Claire illustrated one way, and that was to focus on the courts. How can the courts begin to use the UN Declaration to at least take it into consideration? And how do we as Indigenous peoples, for example, at the Assembly of First Nations, there is no resolution that comes to the floor without being attached to one or more articles of the UN Declaration. So it's an ongoing self-education, I would say, because each time we make a decision, it's based directly with a UN Declaration article. So we have over 600 chiefs. So what we found is that we're teaching in that way through the chiefs' resolutions about the UN Declaration. Corporations and investors are beginning to look at their own corporate policies and asking, how can we change or influence our corporate policy by using the UN Declaration articles? For example, the calls to action on free, prior, and informed consent. So after we were done, we actually did a study because we asked ourselves as a commission, what were the 10 main teachings that we learned from this investigation across Canada? It's been termed the largest ever in history consultation of Indigenous peoples, the Truth Commission. When we looked at it and we said, what was the main teaching? Well, it was interesting because the UN Declaration was referenced in our hearings so much we thought, why don't we use this then in a good way? So we called on Canada to use the declaration as a framework for reconciliation, as I said. That was the number one principle of the 10 principles that we concluded on as far as the commission is concerned. I'm going to skip over the principles real quickly here because of the time, but I want to focus on the 9th principle because it requires political will, joint leadership, trust building, accountability, transparency, and investment of resources. That's what we needed to do to have a good start on reconciliation. And also reconciliation requires a sustained public education, especially through and among the youth. So those were the 3 of the 10 principles that we concluded on. But it was interesting because before the commission, the Royal Commission on Aboriginal Peoples also had 10 principles that they concluded on. So did the Government of Canada release 10 principles after the report. What were their principles? And the UN Declaration itself has principles. So we looked at these 4 sets of principles and we thought, what is the common thread among all of this work, all of these principles? And the first one of Canada's principles, I think, is really important for us because it focuses on the very fundamental right. And they said that all relations with Indigenous peoples need to be based on the recognition and implementation of their right to self-determination. That's the one principle that's in all the 4 studies that have been done among Indigenous peoples. So I think it's really a very, very important observation that now's the time actually to be asking how do we do that then? The 5th principle that Canada has concluded on is also very interesting because it's about treaties. Treaties, agreements, and other constructive arrangements between Indigenous peoples and the Crown. And these have been and are intended to be acts of reconciliation based on mutual recognition and mutual respect. And the following one is one that's really challenging for many in terms of implementation. And that's the meaningful engagement with Indigenous peoples. In Canada, they say to aim to secure their free, prior, and informed consent. And we thought that was actually a little bit of a step back because they shouldn't be aiming to secure the free, they should be securing free, prior, and informed consent. So we took a bit of a challenge on that. So let me just jump to the conclusion here because I'm taking too much of your time already. But just to give you some examples at the corporate level, the Canadian Association of Petroleum Producers, companies like ConocoPhillips are embedding the UN Declaration in their policies now. In fact, the Energy Forum that's held in Canada, among all the private industry dealing with energy, have also been looking at the UN Declaration now, which is a very good thing. Yesterday, Claire Charters talked about judges looking at the UN Declaration in their area. Well, in Canada, the judges at their conferences are now asking themselves, first of all, how do we inform ourselves about the UN Declaration? And then how do we take it into consideration in our decision making? The police officers at their annual general meetings are also looking at how do we implement through policing the UN Declaration. In fact, law societies are also doing that. The benchers in the law societies are making an effort to really work on getting familiar with the UN Declaration and implementing it. Economic reconciliation. The Aboriginal Economic Development Board is doing that, looking at how do we use the declaration in business. What are the calls to action for the business area? For example, through their joint ventures or through conferences on pipelines or oil and gas, they're looking at how to, I would dare say that the last two cases, the Mikisew case and the Trans Mountain Pipeline case, actually the solution is in the declaration. But sadly, the courts didn't even look at it. It's too bad, but anyway, sidetrack. Universities and colleges, the faculties of law and medicine and education are now teaching about the UN Declaration. So public and private schools, through the curricula, the schools across Canada are now having to reassess the curricula and how to teach the accurate history of Indigenous peoples in Canada, how to teach treaty and UN Declaration in the schools. Nonprofit organizations are looking at how to use the UN Declaration. Political organizations, sports, my most favorite one, and I'm not gonna bore you with sports because I have one example. Indigenous peoples, through conference, through the Confederacy of Treaty 6, for example, all our priorities in the work that we do are now linked directly with the UN Declaration. But what's missing is what Daly, Dr. Sambo, Daly Sambodoro mentioned yesterday, not only to implement nationally, which is what's happening in a real good way across Canada, and these are just some examples, but what's missing is the monitoring. There's so many good things going on across Canada, but nobody is monitoring what's going on. So we offered a call to action that there be a National Council for Reconciliation established. Unfortunately, it's not established yet. However, we expect an announcement very soon on the National Council for Reconciliation. And I had the honor of chairing this committee, and we're focusing a lot on hope. Hope. When I first looked at hope, I found out quickly I didn't really understand what hope is in a way until I was talking to a grade 8 classroom, and I asked them what their future looks like, and they said to me, well, actually we're just waiting to die. A grade 8 class of students, and I thought there's a very important message there that they've already lost hope. So in order to repair the harm, as we said, we have to go back to a hopeful future, create a hopeful future. The National Council on Reconciliation can do that. We think and believe that they can do that. So hopefully the announcement will be made soon. And I'll close with my own school picture. I spent 14 years in residential school. Here's some people call it a jail, but it's a 4-story building. At the top floor was the nuns. The next floor, sometimes I'm asked how I know this. There was the girls' dormitory. But I did have 7 sisters, actually, that lived on that floor. The floor below that is the classrooms, and then the floor below is the dining area. But around us, there was barns. There's a horse barn, there's a cow barn, there's a chicken coop, there's a hog barn. It's actually to show that we actually were very self-sufficient, but also if you were to do that today, you'd be charged pretty quickly with child labor. And lastly, to conclude, because you can't see the fence, except with this picture, it's the same building, but in the front of it, there's a fence. Can't see it. And I say, well, it's a barbed wire fence. People say, oh, so what? Get over it. It was an electric fence. And that's where I was there for 11 years of my life. So let me conclude with a good story, because this is an illustration on what can be done when somebody tries to attack your language, your culture, your beliefs. Go ahead, sorry.
No, go ahead and then I'll play.
No, we asked ourselves, can we use sport as a medium to promote and advance reconciliation? And of course, my own sport, hockey, they stepped up and said, yeah, let's do that. What message do you want to deliver to the audience that watches a hockey game? And I said, well, the residential school history was an assault on our languages, on our cultures, our families, and our communities. So what can we do then through the medium of sport to showcase our languages, to showcase our culture, to showcase that this policy failed. They didn't succeed. They almost did, but they didn't succeed in killing our language and killing our culture. So here's an illustration of how it can be done, at least in Canada, is one way. So if you caught it, there was an Inuktitut, Cree, English and French version of our national anthem. So we use our language, as I say, to try and bring back about not only the healing, but the reconciliation through sport. So thank you very much, and again, I apologize for taking so much of your time.
Okay, I'll get started. Meraltiok, televisin Naiomi Dalhousie listigocha basnaidalagwe chibuktok. Well, dasi begisin exitbug. I'm very happy to be here today, and thank you to our host, Treaty One Nations and the Métis Nation. I would really like to thank the organizers, Celeste, Brenda, Laura, Helen. I'm truly appreciative to be here. I find I'm learning so much, and it's wonderful. Miwaram, I appreciate it. Thank you. So Celeste asked me to revisit a presentation I gave last year in January. There was an emergency meeting that was called by Canada on First Nations child welfare. To give you a little bit of a context of why we were called to this emergency meeting, in 2 years earlier, in January 26, 2016, we received a watershed decision from the Canadian Human Rights Tribunal. The complaint was spearheaded by the tireless efforts of children's advocate and Gitsan social worker, Dr. Cindy Blackstock. She was also supported by the AFN in that complaint. The decision was a watershed decision because it found systemic underfunding of child welfare services on reserve provided to First Nations children. And it was very clear from the decision that this was known to the government for well over a decade. There was evidence on the record where the government knew that it wasn't providing anywhere near the same level of services that were provided by provincial governments for comparable services off reserve. So it took a little while for Canada to get its act together. It took, in fact, about 4 non-compliance orders issued by the tribunal after the January 2016 decision. But under the leadership of Minister Philpott, who was recently shuffled again, Canada started to get to work on implementing this decision. And so that was the impetus for the January 2018 meeting last year. One of the things that Canada is proposing is legislation. It probably will table it fairly shortly. But my presentation, there still is, the parties are working together and better than before. There still remains some outstanding issues. They're still before the tribunal. I think Cindy estimates somewhere between 22 to 26 continuing outstanding issues with respect to implementation of the decision. However, there is work being done. And I made this presentation last year about possible ways forward to reform child welfare, which was the main theme of the decision of the Canadian Human Rights Tribunal. I want to say that so my case study is primarily on child welfare, but the problems are the same for other essential service areas in First Nations communities. So it's the same for social assistance, health services, education, housing, infrastructure, water, policing, emergency services. What I'm saying is pretty well, it could go for all of these other areas as well. So basic essential service areas. So one thing to know that's important, why there's these problems. It's because the structure of how these services are provided is very, very convoluted. So to tell you, off reserve, it's usually these services are provided by the provinces, it's controlled by the provinces, they make the policy, it's delivered by their employees, it's all run provincially. But when it comes to issues on reserve, given the division of powers between the federal government and the provincial government and the failure to really recognize Indigenous self-determination, as well as, I would say, long-standing neglect by both levels of federal and provincial government of these issues, what we have instead is a situation where the federal government funds essential services on reserve, and as you've heard, underfunds them. And there's also human rights complaints going on right now in respect to several of the other service areas I mentioned, claiming systemic underfunding. We get the feds funding, you have provincial service standards applying, so provincial rules about how these services are to apply are what govern. And that happens either directly through the law applying directly or indirectly via federal policy. It's a complicated explanation of how that works, but essentially what you need to know is that generally provincial laws are what are applied to services on reserve. And since the 1980s, 1990s, prior to this, it was either federal or provincial staff that would provide these services. It is First Nations who now, through agencies or through band councils, deliver these services themselves in their communities, but not in a free way or with a lot of control. There are many, many strings attached. In fact, they don't, all of the main terms are dictated by the federal government or by provincial standards. There is very little flexibility, and this situation, imposes incredibly onerous reporting standards on First Nations, and some communities find themselves spending most of their time meeting reporting requirements as opposed to delivering services. I have written extensively on this. I believe that the way that it is structured, you could argue that it constitutes a violation of the rule of law. It provides way too much discretion for a federal government to be able to make discretionary decisions, change things on a whim, and there's really very little accountability provided. It also, the structure of it prevents Indigenous people from being able to really hold government accountable or go to the courts to ask for accountability. And most importantly, this system exacerbates the poverty that we find in Indigenous communities. Poverty stemming in part from intergenerational effects of colonialism. However, it's not, the poverty is continued and exacerbated, I would say, by this system. So this system is actively continuing discrimination. It is, it's not simply just a matter of the past, but the underfunding and how these whole systems are structured, I argue quite strongly, is ongoing daily discrimination. Now, so at this, moving on, so that's my context for you, but what I would like to say next is that, I believe part of the solution, and Daley spoke to this yesterday, empirical data supports. The few examples where we do have Indigenous people self-governing in Canada supports. Even some government reports support the recognition that if you give Indigenous people the control over these services and their and decision-making over their lives generally, you get better outcomes. And Daley said this yesterday, that if the states would just get out of the way, that would make things much better. So what this presentation does, this case study, is present different mechanisms through which control could be exercised. So this was my assessment of various ways that Indigenous people could gain more control over child welfare and these other areas as well. A few key definitions as I get into this. I have here the definition of self-determination I took from the RCAP report, 1996, defining the right of Indigenous peoples to choose their destinies. And in Canada, it means that First Nations, Inuit, and Métis have the right to negotiate the terms of their relationship with Canada and choose governmental structures that meet their needs. So it's a choice. It's a choice of what governance structure meets their best needs. Included in the concept of self-determination, but somewhat separate from it, is the concept of self-government, which is one form of choice that involves the greatest amount of autonomy for Indigenous groups. So it's the ability of Indigenous peoples to enforce their own rules, resolve disputes, problem solve, and establish their own governance institutions to carry out these tasks. And it would be according to their own needs. Another key definition that I provided in this presentation is self-administration. So self-administration is not self-government. It is essentially the downloading of programs and services to be delivered by the Indigenous group, but other governments make the decision the key decisions over the program content, standards, and funding. And I would argue that this is our current model of how these essential services and child welfare are delivered. The other key term that I'd like to draw your attention to is comparability. So this is reference to a federal funding standard. And it's a funding standard, and it's also a program standard that Canada has adopted with respect to the delivery of essential services on reserve. And basically what it requires is that funding levels and standards be comparable to provincial standards. Now, this is not set out in legislation. It actually comes from a Treasury Board authority, so a cabinet authority given to the Department of Indian Affairs, Indigenous Affairs, to provide these services on reserve according to comparable, in a way that is comparable to the provinces. This comes from 1964, and it really hasn't changed since. And like I say, it's not legislated. Sometimes I find the federal government treats it as if this concept was a constitutional imperative, but it is simply just a policy that they've developed since the 1964. And I'll say a little bit more about that. I'm going to fly through these key principles in developing Indigenous child welfare models. Willie has touched on a lot of them. The fact that TRC calls on Canada to adopt UNDRIP, and Canada has said it's going to adopt UNDRIP, and the recognition that self-determination should be at the basis of our relationship. Those are all guiding principles. The other guiding principles I think I will say is that Canada does have the constitutional authority to be able to, in partnership with Indigenous people, make a real change. I will say that in the Caring Society and in various other cases, Canada consistently argues that these services are provincial, and it's a provincial responsibility, not a federal responsibility. And then the provinces argue that it's a federal responsibility, and so it goes back and forth. Indigenous people in Canada often, because of the constitutional division of powers, tend to be treated like political hot potatoes. But in fact, the Watershed Caring Society decision does confirm very clearly that Canada, in fact, does have the power to be able to make changes in this area. I will skip 5, and my next key sort of point from the Caring Society decision is that the tribunal in the Caring Society case found that the comparability standard that I defined for you a moment ago is discriminatory, because it fails to, and this is a quote from the decision, meet the distinct needs and circumstances of First Nations children and families living on reserve, including their cultural, historical, geographical needs and circumstances. And so this idea of simply requiring all services on reserve to both mirror in terms of funding and standards the provinces was found by the tribunal to be discriminatory, to be assimilative, and in fact it found that Canada wasn't even really following this prescription anyway. It was providing well below provincial standards. But the key point from the decision is that it's not just the requirement of meeting substantive equality, and this is what the tribunal found. It's not formal equality that we are trying to meet in Canada. In fact, it's substantive equality, and that's informed by our own domestic human rights law and equality law, but also international documents. So the tribunal did look at international instruments, including UNDRIP and others, but found that the standard is that Indigenous people are entitled to services that meet their needs, circumstances, and historical circumstances. And it's not simply enough to simply mirror the provinces. So this is really quite significant, and I don't think even it receives enough attention when we talk about the impact of this decision, that the finding that as a matter of substantive equality and international human rights, that we are entitled to the right to be different and to receive funding based on the fact of our differences, and that's completely consistent with human rights. So with those principles in mind, and I'll try not to take too much more of your time, I'll just kind of breeze through some of the options that I had reviewed at this in my presentation. So in terms of jurisdictional models, the status quo is, as I say, a model of self-determination. I'm sorry, is not. The status quo is a is self-administration. So it's a downloading of services to Indigenous people, and it's based on comparability, which has now been found to be discriminatory. So it won't do. And also, it's not self-determination if Indigenous people don't choose self-administration. Self-administration could be a fine model, but it has to be chosen. But the way it works in Canada is that there's very little choice in receiving, essential services in the way that they are been given in the last 50 years. Indigenous people accept funding arrangements with the federal government. They generally don't have a choice. Some First Nations have described it as having a gun to their head in terms of, it's either take this money and deliver this services, or you have no money and no services. And we're talking about key day-to-day essential services for the most marginalized people in Canada. So there's really not much choice. So this isn't not a model of self-determination. Another model is accommodation within provincial legislation. This has happened to some extent already in Canada. Some jurisdictions like BC and Alberta do have provisions in their child welfare legislation that attempt to accommodate First Nations difference in some way, but it leads to a patchwork. It also, some provinces will do something but have felt that constitutionally they are limited in terms of to the extent to which they can accommodate First Nations. So this is not an ideal model, and it leaves policy making to each individual province. So you get a disparate sort of approach. So generally not thought to be the best approach. Also, I don't have too much time to go into it, but the application of provincial rules that are developed on policies that are informed by Euro-Canadian viewpoints is, generally argued with respect to all these services to be quite inappropriate, very assimilative, not taking in Indigenous worldviews or even realities. I could spend a lot more time on that, but this is just another reason why provincial jurisdiction isn't the best. Another option in Canada is the just do it model, which is First Nations just saying, heck with it, we're just going to exercise our jurisdiction. And that is good, and some communities have done that. The only downside to that is that there's risks, and if provincial or federal governments don't actually acknowledge that jurisdiction, then you have situations of conflict. And so it's not an example from child welfare, but there was a community in Nova Scotia, a Mi'kmaq community, that decided to develop its own tax regime by collecting sales tax and using it to develop a social program to assist elders in the community. CRA, the Canada Revenue Agency, did not approve that, nor did Canada, and at the end of the day, after 2 court battles, the First Nation was left with a $25 million tax bill to CRA. So, the just do it model, as much as, I would say that, ideologically I agree with it, it just leaves so much risk. So there is a conversation to be had about there need to be some role of the state. It may be, but it's a formal role for the state, and maybe it's just them formally getting out of the way. But I do think there needs to be some discussion of the role of the state. My next model is sectoral self-government agreements. This is the one approach that is available within Canada. You can negotiate an agreement, but Canada calls the shots of how these negotiations happen. It has fairly restrictive rules around funding. And in fact, only one First Nation, there's only been one sectoral self-government on education that's been negotiated for the 30 years that this policy has been in place. So not very effective and very long. There's a mechanism by which people can pass laws based on the Indian Act. I would say that there's bylaws that Canada used to control them and actually had approval authority over these. However, in 2014, Canada stepped out of the way on that. But there's something that most people find fairly offensive about using the Indian Act as a tool to sort of self-govern or self-determine, and I appreciate that. I do think that there's some arguments that you can make to sort of expand the jurisdiction quite broadly, but most people don't think that this is a viable option, the idea of using the master's tools to take down the master's house. what needs to happen with all of this is that there needs to be changes in the federal funding agreements, and that, one of my fears with how Canada has been moving on the file on the last couple years is that they're talking a lot about jurisdiction, but what needs to go hand in hand with jurisdiction, obviously, is adequate funding. And I have a little bit of fear in terms of what's going to be proposed, and I've taken a look at the draft legislation. It's not available publicly yet, but it just says that Canada will sign a federal or a funding agreement. It doesn't actually put into place any parameters about, adequate funding or what kind of funding. So, as we talk about jurisdiction, there definitely needs to also be a discussion about adequate funding. You cannot have you must have the two together. And that's consistent with UNDRIP. UNDRIP Article 4, as well as self-determination, recognizes the right to the ways and means for financing of Indigenous peoples' autonomous functions. So that's really key. An option is federal legislation on child welfare. This is the model that Canada is currently taking to addressing the child welfare issue. We'll have to see where the proof in the pudding is on this. It has the potential to be very good. In the U.S., there has been child welfare legislation allowing Indigenous groups to implement self-government over child welfare. It has its own problems. However, this has been the sort of inspiration for the approach that Canada is going to be taking. I guess the only concern we'll see is that Canada tends to still want to be fairly prescriptive, even when it's admittedly trying to give more control. And in the draft that I've seen, its team seems to be putting a lot of parameters about how Indigenous people can self-determine. So that seems to be a bit problematic. And a final approach that Canada could take is that it could actually pass federal legislation on self-government that's general. The Royal Commission report on Aboriginal peoples had suggested that this should be a temporary means towards moving to longer treaty relationship. I have argued that we should actually, this is an interesting suggestion and we should reconsider it. In the work that Canada's done in the last year, Canada announced that it was going to be moving forward on a rights recognition framework. And there was some sort of talk that they would be looking at RCAP in terms of moving things forward. I think those of us who were involved found that what Canada was putting on the table really didn't look anything like what RCAP had proposed. Still was taking an approach that seemed fairly prescriptive, and was mostly about defining who could be rights holders. There was in the proposal some recognition of jurisdiction, but in a really limited way, and in a way that over areas that Indigenous people already exercise quite a bit of jurisdiction over governance, for example. So this is a possibility, but it's not one, it seems, yet that Canada is truly contemplating yet. So I guess in conclusion to these various models, they all have pros and cons. And I think the biggest challenge that we face in Canada tends to be about, we still have a government that, even though it's becoming more receptive to more control, again, has a real hard time of giving up control and feels like, in a kind of a paternalistic way, still wanting to, guide and ensure that the Indigenous groups, exercise their jurisdiction in a certain way. And I think that is problematic. Anyway, sorry for going a bit over time. Thanks.
Terve teille, hyvät rahvas. Suuret passivot järjestäjille kutsustada, suuret passivot yleisöllä huomiosta, onnia ja lykkyä. It was a little introduction in the Karelian language, which is a language spoken in my region by Indigenous people, the Karelian. Republic of Karelia is located in the northwest part of the Russian Federation, close to the Finnish-Russian border, and in between St. Petersburg and Murmansk region. So this is the place where I live and run an Indigenous NGO, which is called Center for Support of Indigenous Peoples and Civic Diplomacy, Young Karelia. And also I'm sitting in EMRIP for the region called Central and Eastern Europe, Russian Federation, Transcaucasia, and Central Asia. But I will build my presentation on the case studies coming from my region, because I think that it represents the situation in the entire region, actually in the bigger region. Firstly, I would like to refer to some articles, consecutive articles of the UN Declaration on the Rights of Indigenous Peoples, which are talking about the cultural and linguistic rights and educational rights as well. So, because my presentation will be mostly on these particular rights of indigenous peoples. So, first of all, Article 13, which recognizes the right to revitalize, use, and develop histories, languages, oral traditions, philosophies, writing systems, and literatures of indigenous peoples. Article 14 says that indigenous peoples have the right to establish and control their educational systems. And another article, Article 15, which recognizes the right to the dignity and diversity of the cultures, traditions, histories, and aspirations of indigenous peoples. I would also like to refer to one of the studies which the expert mechanism has done. One of the first studies of MRIP on the right to education. And in that study, expert mechanism recommended that states follow a stepwise policy that could help promote all indigenous languages. And also MRIP says that sufficient funding should be allocated to support the development of teaching methods, literacy, and so on. Now I would like to showcase some examples of how these recommendations and these provisions of the UN Declaration have been implemented in my region. So first of all, it's happening right now in my republic, a lot of protests in different rural areas, in villages and municipalities where indigenous peoples traditionally live. People protest against the closure of schools. In particular, in some villages, the government of the republic decided to close high school, like two last classes, and remove those children from the families and put them to residential schools in bigger settlements. So that's why it's very interesting that, for example, while in Canada, this residential school experience is somehow decided that it has been a bad experience and should eliminate this legacy. But in Russia, also we had residential schools in the past, but now it seems that the government decided to come back to this bad experience, saying that this is not against the indigenous peoples and indigenous languages, and this is not against those villages, but this is just because the government would like to take care about the quality of education, because they think that those small schools, they cannot maintain a good quality of education for children, and they would like to unite schools and concentrate them in big settlements and put people, pupils there. So this is about how to control on educational systems and traditional educational models in indigenous rural settlements. Another interesting development is about controlling and developing on writing systems of indigenous peoples. So in my republic, for example, I should mention that there are 18 republics in the Russian Federation, and Karelia is one of them. So all other 17 republics have 2 or more state languages. So Russian language is, of course, a state language in all of them, in the whole country, but 17 republics also have other state languages, which are mostly indigenous languages, spoken by minorities, indigenous minorities who, after whom those republics have been named. And the Karelian Republic is the only republic in Russia where we have only one state language, which is Russian, and Karelians have been struggling for the Karelian language to be also proclaimed as a state language, because it's so important for us in terms of the language prestige and more opportunities for teaching that language, for keeping that language spoken in the media, in the school system, in the administration system, and so on. But the problem is that the federal law on the languages of the peoples of the Russian Federation, which was amended in 2002 by the State Duma, the Russian parliament, and the deputies observed that there are some movements in the Republic of Tatarstan, which is one of the most powerful republics in Russia, that Tatar people wanted to change their script from using Cyrillic to the Latin script, and the deputies wanted to stop that movement somehow, and because they thought that this is a threat for the Russian national security and so on, and somehow Karelian language, which is also using Latin alphabet, Latin script for different reasons, but also, most importantly, for the phonetical reasons, because the script reflects very well the phonetics of the language, and the Finnish language, which is a kindred language for the Karelian, is very important source for the new vocabulary and development of the language. So that's why Karelian literacy and Karelian writing tradition and writing system is built on the Latin script, and somehow the federal law is an obstacle for the Karelian language to be a state language in the Republic. And most recently, last week, the Council of Europe, the Councils of Europe Advisory Committee on the Framework Convention for the Protection of National Minorities published a report under the 4th monitoring cycle, because Russia is a state party to that convention. And in that report, this situation with the Karelian language and the need for the indigenous peoples to be able to control their writing system and identify themselves, the writing system. So this situation was described in the report, and the Russian Federation responded officially to the opinion of experts of the Council of Europe, and the response was very bad, actually, because the Russian Federation says that this is all absurd, what is written in the report of the experts, because Russian policy strives to harmonize inter-ethnic relationships and so on, and no one indigenous language has disappeared in Russia so far. So this is a very unfortunate situation, because it has been lasting for like 30 years already since the collapse of the Soviet Union, and Karelians are still trying to take the language to a higher level possible. Another good example of how indigenous peoples cannot control actually their the languages in different systems is the role of languages in the current, in the modern democracy. For example, the federal law in the Russian Federation says that indigenous peoples, and all peoples actually, not only indigenous, but all peoples can have a possibility to vote, to use ballot papers in own languages. So if they claim that they want to vote and to go through the election process in own indigenous languages, it means that the government should provide these opportunities, and the Central Election Commission should provide these opportunities. In my republic, for example, it is also not the case, and somehow the local election commission decided that the federal law should not apply in the republic, because first of all they say that all Karelians understand Russian, So that's why there is no need for the Karelians to have own ballots in the Karelian language. But in the federal law, there is no word about this. And also they say that there are no areas of traditional residence of Karelian people identified by the law, which is not true because I mean the executive branch in Karelia has already identified those areas, and it's already documented in different orders by the executive branch. So it all says that the government sometimes thinks that indigenous languages are not a human right, but mostly part of the cultural heritage, and somehow the government wants only to protect and develop different ensembles, festivals, use of languages in those cultural activities, but not in the most crucial areas where the languages should be existing too in order to be vital in the administration system, for example, in the education system and in the media, first of all. In terms of the cultural heritage, there are also some obstacles. There is a UNESCO Convention of 2003 on the protection of the safeguarding of intangible cultural heritage, which Russia is not part of, unfortunately, and it limits indigenous people's opportunities to promote their intangible cultural heritage into the international list of intangible cultural heritage, which is very important for indigenous peoples. And in terms of, there are there is a lot of information and a lot of movements in terms of promotion of the ethnocultural tourism in many areas in the Russian Federation, and unfortunately, the government somehow doesn't see the opportunities of the real protection of the languages and cultures of indigenous peoples. They just would like to somehow, they support those ensembles who are composed of singers, for example, who don't understand even what they sing about. So they just learn those words, those songs, and they perform different festivals. They also perform abroad and represent this culture, but somehow they themselves don't understand, and they are not even bearers of these cultural traditions. Of course, for the indigenous peoples, it's very important that the United Nations General Assembly has proclaimed this year as the International Year of Indigenous Languages, and in EMRIP, in the expert mechanism, we worked we keep working very closely with the UN Human Rights Council, because we are a subsidiary body of the Human Rights Council. And last year, the Council adopted the resolution, traditional annual resolution on indigenous peoples' rights, and it also stated that and encouraged states to participate actively in the organization and implementation of the activities related to the International Year, to uphold the spirit of the International Year. And Russian Federation was among the first UN member states who established a national steering committee for the International Year, and the action plan has been adopted. And also on the subnational level, like in the Republic of Karelia, for example, there is a Republican action plan for the International Year. And it was very interesting how these plans were considered and adopted, because myself, on behalf of my NGO, so I submitted some proposals to the action plan, and unfortunately those proposals were not in the final action plan adopted by the government, because they said that those proposals were international events, international projects, and we cannot have international projects in such a list because of different. I mean, you know, this Russian EU, Russia-West relationships are not good right now, But how about the fact that Karelians are a cross-border people, and many of our projects are cross-border projects and should be, because our people lives in Finland, in other regions of the Russian Federation. So it's very important to keep it internationally, these activities. But the indigenous peoples themselves, they are very active in terms of promotion of the International Year of Indigenous Languages, and they have a lot of good projects in which in different spheres, like for example using internet and information communication technologies for the promotion and modernization of indigenous languages. One of these projects is, for example, Civil Society Network for Preservation and Revitalization of Indigenous Languages, which has already supported 10 indigenous initiatives, very local indigenous initiatives, because we really think, and when we discussed this international year in the UN level, we also thought about the local activists who should be supported, because sometimes they are a side of global movements and so on. And in this project, and like a number of NGOs decided to support local activists and so-called local indigenous language activists to revitalize their languages. And one of the most known and most effective initiatives in the sphere of indigenous languages is the house, so-called House of the Karelian Language, which is actually a physical place where indigenous representatives in the village can get together and exchange between generations, because sometimes, I mean, in many villages there was no mode, no fashion for speaking indigenous language anymore. And this particular project has revitalized in a concrete village a fashion to speak the language, and different generations, they get together and exchange thoughts and practices and so on. And in this language house, they have also this language nest, which is a method which was born, I understand that in New Zealand, but then has gone to other regions too, and is used, for example, to Karelia. It has come from Finland, where it has been used for the revitalization of the Inari Sami language. And unfortunately, the state, the Russian state, doesn't want this method to be used widely, because they think that this is somehow not beneficial for the kids, because the educational system is not set up fully for the indigenous languages. Because if the kids, for example, go through this kind of language nest where they speak only minority language, yes, and then they go to the school, and they would be not competitive to other kids who speak only Russian, for example, and spoke Russian in the kindergarten. But I mean, this is of course not true, because all the scientists, they unanimously think that the more languages kids speak in the childhood, so the better they are in the studies further. But this kind of private language nest is working, and working very well, and even the official kindergarten in that village is not so popular among the population right now, and people strive to this very small language nest and would like their kids to speak Karelian again. And finally, just want to maybe refer to one more, because I promised the organizers to connect somehow this linguistic and cultural rights to the economic and social rights. And for example, in Russia, we have this ethnological impact assessment idea, which is another name of this is ethnological expertise. It's kind of before implementing different projects, like in infrastructure projects, oil and gas companies are running in different regions. So this kind of ethnological impact assessment should be done in order to also count what kind of compensation could be paid to indigenous peoples for the loss of lands, ecological damage, and so on. But how this ethnological impact assessment could take into account the loss of language, for example, or damage caused to the cultural traditions, this is not fully taken into account in this kind of idea of ethnological impact assessment. That there should be a lot of discussions how to do it better. And of course, I think that international mechanisms, like the expert mechanism, for example, could be of a good help for member states, in particular Russian Federation, in terms of advising how to better, how to improve the legislation, the law enforcement, in order to make it more consistent with the declaration and international standards. And of course, those people who say that Karelian language, for example, or indigenous languages should not be supported because they are dying, and this is a logical process, because some people in the federal government, for example, they say that so we cannot do anything to those languages, and also because they are not modern, they cannot serve as state languages, for example, because they don't have vocabulary enough, they don't have anything. And this is a good example. Like we, number of years ago, we translated the UN Declaration on the Rights of Indigenous Peoples into Karelian language, and it means that the language can fully serve every purpose, because if this kind of very complex document with the complex vocabulary could be translated, so the language is very modern and can be used in all spheres. So thank you very much for that. And sorry.
So I wanted to say to our three amazing speakers, what a wonderful range of ideas and conceptual frameworks for us to consider. We all learn something with every presentation, and in some cases reminded as well. And especially in this year for the International Year for Indigenous Languages, the connection of language to our children who are in care. What will that commitment be in federal legislation? Or as Willie showed in the video, what an amazing video that was at the closing of the TRC, and the national anthem for Canada to be sung in the three languages, the Métis and Indigenous First Nations and the Inuit. I think it is our responsibility that we have, firstly, before we talk about the rights and the responsibilities, allows us then to identify the rights to choose our ways forward, and to the speakers what you have provided and the contribution to this. Willie talked about the 10 principles from the Truth and Reconciliation Commission. Out there on the table is this, and if you haven't picked up at least one copy, you should pick up 2 or 3 or 4. Because if you run out of them, the National Center for Truth and Reconciliation down the street here has more copies. And why I'm suggesting it is in English, I'm not sure whether it's in French, but it has the 10 principles that Willie talked about from the Truth and Reconciliation Commission in one section. The second section contains the 94 calls to action, the 94 recommendations, maybe, for those who want to kind of figure out what they are, that they are in this little booklet. And the third document is the UN Declaration on the Rights of Indigenous Peoples, compact in one book. I've given out hundreds of these to politicians at the national level and politicians and bureaucrats in the provincial level in my province. In one meeting, I gave out 4 boxes of these. There are about 400 in each one box or some, and they went up like that. Then they actually in the province, the chief of the head of the civil service ordered more boxes of this booklet for all of the civil servants, the public, those who work for government, to have a copy. So it's judges, as Willie said. Let me say thank you to our speakers, and please give them a round of applause for their excellent presentations.